Welcome to another episode of the CarryTrainer Higher Line podcast. Branca is considered not only an expert, but he's probably one of the experts. I wouldn't say that, that's a little douchey, but he is considered to be one of the top people in the field of self-defense law, which, as you'll find out, is different than criminal law.
All right, folks, thank you very much for your attention. I really appreciate it. Of course, I'm a lawyer. I've been doing this use of force law for more than 30 years now, meaning defense of yourself, defense of other people, defense of property. I don't do anything else. I don't have a generalized criminal law practice. I don't do DWIs, or it's a use of force. If you've shot someone or threatened to shoot someone or stabbed someone or punched someone or over defending yourself, your family, a stranger, your property, those are the kind of cases I work. Those are the only kind of cases I work. I'm also a lifelong member of the gun community. So I was a small bore rifle competitor as a kid. As an adult, I got into USPSA and then IDPA. Where's our IDPA champion? They're at the end of the table. What's your IDPA number, sir? How many digits is it?
I started 2 years ago.
All right, 2 years, so a 5-digit number. If I told you I had a 4-digit number, would that sound like a low number for IDPA? A 3-digit membership number?
No, I know 13, which is don't give it. Number 13.
I'm number 13.
Ah, really? Are you?
Yeah.
So you were around that. Were you part of the directory of IDPA?
I wasn't. I helped edit the first rule book. I was in the satellite of the organization when it first got started. So I've been doing this for a long time. But that's what got me interested in all this self-defense law stuff, because I was going to gun matches and people would ask me, when am I allowed to shoot somebody? And I didn't know the answer, even though I was a lawyer, because they don't teach us this stuff in law school, as I'll talk about. So any claim of self-defense has 5 components, 5 elements, like 5 links in a chain. I'm going to talk briefly about those. But my book, which you'll all get, talks about those for 200-something pages. So I'm not going to spend a lot of time here. Instead, because you are a higher level group here, I know you can read the book and understand the book when you get home. I'd like to share with you some insight into how the criminal justice system really works, handling these cases. Things that you can't get from a book, that you won't get from anybody else, and it'll probably scare the shit out of you a little bit. It ought to, because it's a scary system. So let's get right into it. Yesterday, Mickey asked on the range, hey, if you do everything right, you probably won't have a legal problem. Well, you probably won't. But the stakes are extremely high, and there's a possibility you could have a legal problem, even if you do everything right. And we can't prepare ourselves just for what might happen if everything goes our way. We don't do that when we prepare for the physical fight, right? We don't prepare for a physical fight. Say, hey, if we just ask that guy to stop punching us, that's all we need to be able to do, right? Just politely ask him and he'll stop. We say, no, we got to be prepared for the worst case scenario. Well, for the legal fight, we also have to be prepared for the worst case scenario. Now, we think of self-defense, of course, as a physical act, defending ourselves physically. That's what we're all learning how to do here this weekend. But it's also a legal defense, a technical legal defense that's raised as a defense to a criminal charge. So in my world, when I'm talking about self-defense, that only comes up if you've done something that a prosecutor thinks was unlawful. And he's going to charge you with a crime. If you've killed somebody, it could be murder or manslaughter. If you shot somebody with a gun, it could be aggravated battery. It could be aggravated assault, a whole series of offenses. All of those are good for most of the rest of your life in prison. So aggravated assault with a firearm, good in most states for 10 to 20 years in prison. Manslaughter, pretty similar. Murder, life in prison without possibility of early release. So even if there's a low chance that you would have a legal problem, you want a low chance of spending the rest of your life in prison? That sucks, right? So what you do when you're facing that criminal charge is you raise the legal defense, the legal justification of self-defense. Could be self-defense of yourself, it could be defense of another person, it could be defense of property. And one of the things I was mentioning on the range yesterday when I was talking about aggravated assault is you have to understand what the crime of assault really is. It's simply putting another person in reasonable fear of imminent harm. So you run up on somebody, they can see you coming, and you have your fist raised, and you never touch them, but you put them in fear of being imminently punched. That's a simple assault right there. Yes, sir?
Reasonable based off whose opinion?
I'm sorry?
Reasonable based off whose opinion?
Whose opinion? It's always someone else's opinion. It's never your opinion. That's the problem. It's other people's judgment. We'll come back to that. You get to an aggravated assault when you put someone else in imminent fear, reasonable imminent fear of deadly force harm, meaning death or serious bodily injury, a maiming injury, a gunshot wound, or they may die. Is that what we're doing when we tell someone, stay back, I have a gun? That's exactly what you're putting that person in imminent fear of deadly force harm for the purpose of changing their behavior, to make them stop doing something that's scaring you, right? You can do that, but now you have to justify it as self-defense. You have to raise that legal argument, but you've already checked all the boxes for a criminal charge of aggravated assault with a deadly weapon. You don't even have to have the gun. They just have to believe that you have a gun. And you've done that because it's their subjective perception of the threat that controls for assault. And as I mentioned, aggravated assault by itself is often good for 10 years. You get to 20 years because most states have a gun sentencing enhancement law. So if you get found guilty of the underlying crime and you did it with a gun, and for most of us, we would have done it with a gun, you can get another. Sometimes the gun sentencing enhancement is more than the underlying sentence. There's some crimes you can be imprisoned for 1 year for the underlying crime and get 5 years mandatory minimum for the gun alone. So the gun changes things. Now, when we look at a criminal charge, a lawyer would break it down into specific elements, right? So you have the reasonable fear, meaning the victim's reasonable fear of harm that's imminent, not some future threat, not I'm going to kick your ass next week, but I'm going to do it right now. And for aggravated assault, the degree of harm has to be deadly force harm, not just some mild injury. And when a prosecutor is charging you with this, what he's saying is, I think I can prove each of these three things beyond a reasonable doubt. If he fails to do that in the minds of the jury, you get acquitted. But if the jury believes, okay, he proved those three elements beyond a reasonable doubt, you're guilty of aggravated assault. Well, the legal defense of self-defense works much the same way. Just as a crime, a criminal charge has elements, the legal defense of self-defense has elements as well. The good news is there's not 500 things to know. There's not 50 elements to a claim of self-defense. There's only 5, and often not that many. It's up to 5. So none of this is rocket science. There's only 5 things you have to remember, which is pretty straightforward. Now, if you just want a sentence form of this, for deadly force and self-defense to be lawful, it's when that would be a circumstance in which you use deadly force or threaten deadly force to prevent an imminent threat of unlawful deadly force harm to some innocent person, yourself or to some other innocent person. And we can break that down into these 5 elements when you parse out that sentence. And if you look at, I don't care what state you live in, it's the same framework in all 50 states. When you look at your self-defense statute, you'll see each of these: innocence, imminence, proportionality, avoidance, and reasonableness. Innocence meaning you can have been the aggressor, right? If you started the fight, you can't claim self-defense afterwards. Imminence meaning you're defending yourself against something that's either actually occurring in the moment or is immediately about to occur. It's not in the past, you're not seeking vengeance. It's not a speculative threat in the future that may never happen. It's immediately about to happen. Proportionality. If you're only being threatened with non-deadly force, you can only use non-deadly force in self-defense. You can't use deadly force in self-defense. You can't go to a gun in self-defense unless you're facing a deadly force threat. If you go to the gun because someone poked you in the chest with their fingertip, your response was not proportional. Avoidance. In about 10, 11 states, technically, there's a legal duty to retreat before you can defend yourself with deadly force in self-defense. Most states don't do that. That's why I say there's up to 5 elements. But there are 11 states that have this requirement of avoidance. If there's a safe avenue of retreat and you don't take it, you lose the element of avoidance. And reasonableness. Everything that you perceive, that you decide, that you do in self-defense has to be the conduct of a reasonable person. And what that means legally is, first of all, you genuinely believed it was necessary. You had a genuine subjective belief in your head this was necessary, which any of us would have, or we wouldn't be using force in self-defense. But that by itself is not enough. That belief also has to be objectively reasonable, meaning a hypothetical, reasonable, and prudent person in your circumstances would have shared that belief. In other words, an irrational belief in the need to act in self-defense is not going to be enough. Now, only 5 elements, not rocket science. At least it's not rocket science on the surface. So you can imagine you only have to remember 5 things. How complicated can it be? The black letter of the law is pretty straightforward here. What gets complicated is the real world. The real world is super complicated. The facts are ambiguous, they're disputed, there's contradictory evidence. Someone has to evaluate all that evidence before they can apply this relatively simple legal framework to what actually happened. But again, most of those 5 elements we are covered in detail in the book. So I'd like to pull the curtain back on the system itself and give you a better understanding of how all that works. That's where the scary things live. So we've all heard the phrase, I'm sure, the criminal justice system, right? If you had to pick one of those 3 words to best describe that system, which word would it be? What's that? System is the correct answer. It is a system. It is a machine. It's a legal wood chipper. And it cares about you as a human being about as much as a wood chipper cares about you if you're being fed into a wood chipper. The most common remark I hear from clients in cases I work with is, I can't believe I'm being prosecuted for self-defense. The system doesn't give a about you as a person. You are just another widget being fed into this machine, another branch being fed into the wood chipper. The second most relevant word in that phrase is criminal. It's a machine designed to deal with criminals. And it's fairly good at that for the most part, but it sucks at dealing with people who are not criminals. You're like an infectious agent in a biological system. The immune system responds against you. Part of that, for our purposes, is 99.99% of claims of self-defense that aren't in the criminal justice system are bullshit. These are bad guys, bad actors whose lawyers are raising this legal defense because that's what you do for your clients. You raise all the legal defenses you can. But when every cop, every prosecutor, every judge has seen virtually every claim of self-defense they've ever seen as obvious nonsense, how do you think they presume your claim of self-defense is going to come out? Exactly the same. They view you as just another criminal being fed into the system. That's one of the reasons the system doesn't care. And justice, folks, does not mean fairness in this context. It means a process. It doesn't care about the outcome as much as it cares about the process. And the process is important, but the key part of the process is that you don't control the process. Other people are now in control of your fate. They are making the decisions that will determine whether or not you get to go home or you spend the rest of your life in a cage without possibility of early release. You have given up all control over the rest of your life to strangers who, at the best of circumstances, just don't give a about you at all. The worst of circumstances, they can gain political capital by prosecuting you. It's to their advantage to prosecute you. And that's a bad place to be. So the moment you get involved in that confrontation, you go hands-on in that fight, you've lost control over your future as far as the legal system is concerned. Other people are making those decisions now. So when we think about the physical fight, we have professional warriors in this room, right? Where's Z? All right. Can I borrow you for a second? Are you available? Okay. All right, yeah, right. So you've been in combat situations, right? You were trained for those. You trained hard for those because you wanted to maximize your ability to win that fight, minimize the possibility that you or anybody on your team would suffer injury or death, right? Yes. But every time you went into a fight, did you ever feel like the chance of injury or death for you or your team was 0? Yep. It's always more than 0, right? That's all I wanted you for. It's always more than 0. When you think about the physical fight, you can train for the fight as much as you want. And you should train for the fight as much as you can, because it's our goal to reduce the risk of losing that fight to as close to 0 as possible. But it's always more than 0. It's never 0. No one here is Superman, right? We're not immune to bullets. It's always a greater than 0 risk. The same is true of the legal fight, folks. The same is true of the legal fight. You can learn all the stuff that I teach, and you can reduce your risk in the legal fight to as close to 0 as you can possibly get it. You can make yourself hard to convict. I promise you that. But the risk is never 0. There's always a risk that it's going to go against you, both in the physical fight and the legal fight. Now, self-defense as a legal offense is what we lawyers call a perfect defense, meaning if it's successful, it doesn't just reduce your legal liability. It eliminates it completely. There is no legal liability. Even if you shot someone in the head, it's just not a crime because it's lawful self-defense. So it leads to an acquittal, but it's very binary. It's like an old school light switch. Either it's on or it's off. Either you qualify for self-defense or you don't qualify for self-defense. And if you don't, well, you have a problem. Because self-defense is not, it's not like other legal defenses. It's not like an alibi defense, right? You're not saying it wasn't me, I didn't do it, I didn't shoot that guy, I was at my mama's house, or Mick's mama's house, whatever, you know. But I wasn't there, I had nothing to do with this. That's not what you're saying in self-defense. You're saying the opposite of that. You're saying, it was me. I shot that in the head. And it killed them. But I did it with the legal justification of self-defense. Right? That's what a self-defense argument is. Well, what happens if your self-defense argument fails? What's left of this? Just the first part. Does that look like a confession? It looks like a confession because it is, folks. In fact, lawyers call the legal defense of self-defense a defense of confession and avoidance. You're confessing to the underlying physical conduct. You're not denying it was you. You're saying it was you. But you're seeking to avoid legal liability through the legal defense of self-defense. But if your legal defense of self-defense can be defeated by the prosecution, it's a walk-away conviction because you've already given him everything he needs for the conviction. By simply arguing self-defense in the first place, you've given him what he needs on the criminal charge. So again, 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. Those are the things you need to know. If you ask me any questions over the next couple days about would this be lawful or would that be lawful, this is the framework we're going to discuss it in. So these are the only 5 words you need to know. I'll ask you, where's innocence, where's imminence, where's proportionality, where's avoidance, and where's reasonableness? If they're present, then you have a valid claim of self-defense. If they're not, and when I say if they're not, I mean the prosecution doesn't have to disprove your claim of self-defense in its entirety. Each of these is a required element in your claim of self-defense. The prosecution, 4 of these 5 elements could be 200% in your favor. But if he can disprove 1 of the 5, your entire claim of self-defense goes away. It collapses entirely. So when he's reading that investigative report from the detectives, he's not trying to completely disprove your claim of self-defense. What is he doing? He's looking at, for him, these are targets of attack. He's looking for any one of these elements he can disprove beyond a reasonable doubt because he knows if he can do that, he's defeated your claim of self-defense. And if he's defeated your claim of self-defense, what's left but your confession and a walk-away conviction and you spending most or all of the rest of your life in prison? So let me pull the curtain back at this point, move a little bit beyond those 5 elements. Most of the information that's out there on self-defense law is bad information. As a lawyer, I can tell you 3 years of law school, we spent 5 minutes talking about self-defense law. Cops get a lot more training in use of force law than lawyers, but most of what cops are taught in the academy is not actually designed to protect them from personal criminal liability. It's designed to protect their department from civil liability. All these famous Supreme Court decisions, Tennessee versus Garner, Graham versus Connor, those are all civil cases where departments are being sued. The officer's not even involved in the case anymore. So a lot of what cops are taught is not the kind of knowledge that's really intended to benefit them. Most firearms instructors are just, it's not because there's anything wrong with them. I'm an NRA instructor. It's because they just were never properly taught this stuff. The internet, of course, is a shit fest. And the media is a shitfest that likes to propagandize against whatever you're in favor of. By the way, nobody cares what you think self-defense law is. Most of the cases I work on, those clients, they thought they were inside the legal boundaries of self-defense because they did what their self-defense instructor told them to do, or they did what the internet said was lawful. You're in court, no one gives a about that. They only care about what the law actually is. Your imaginations of what the law is means absolutely nothing. Unless it's in statute, case law, jury instructions, it doesn't exist when the rubber meets the road and you're actually in court. And unfortunately, a lot of people learn what they think is self-defense law from anecdotes, from news stories about shootings, use of force events, and they say, oh, this guy did this and he wasn't prosecuted, so that must mean what he did was lawful. No, absolutely not, because prosecutors have unlimited discretion in whether they want to charge somebody or not. Sometimes a normally lawful member of the community shot and killed the bad guy outside the boundaries of self-defense, but the bad guy is a known scumbag, the law-abiding guy is a known good guy, he's got to run for re-election, so he chooses not to prosecute that defender when he could have on the legal merits. The next week, you could do exactly the same thing that citizen did and be prosecuted on the legal merits. So don't assume because you heard someone was not prosecuted that what they did was necessarily lawful. It could just be an exercise of discretion, and the reverse can happen too, right? Most of you are probably familiar with the Zimmerman case or the Rittenhouse case. These are prosecutions that should never have been brought. There's literally zero evidence inconsistent with lawful self-defense, but the prosecutor has the discretion. If he wants you to go to trial, you're going to trial. And the expense of going to trial by itself is absolutely catastrophic. Most of the cases, again, killing cases I work on, murder, manslaughter cases, they run up $200,000 in legal expenses pre-trial, before you get to trial. So prosecutors can use the process itself as a punishment. Sometimes they bring cases like Zimmerman, like Rittenhouse, where they know they have hardly any chance of getting a conviction, but they're going to gain political capital and political favor. It doesn't cost them anything, and they know you'll be punished by what? Unless you have 200 grand or more sitting in a mattress just in case you have to shoot somebody to save yourself or your wife, where are you going to come up with that money? Maybe CCW safe, if you remember a CCW safe. That would be not a bad idea. It's also important to keep in mind that nobody knows what actually happened, right? None of the people evaluating your conduct after the fact know what happened in any absolute sense. They weren't there, right? You're not going to be attacked while you're standing next to a uniformed cop, right? The cops show up afterwards. So they weren't there when it went down. The prosecutor wasn't there. The judge wasn't there. The jury definitely wasn't there. So nobody knows what actually happened. People who are eyewitnesses don't know what actually happened in any absolute sense. We all know if you take 5 eyewitnesses and you separate them and you get their stories, what do you get? 5 different stories, right? They each have their own perspective. And I would suggest to you that even you don't know what happened in an absolute sense. Under stress, you won't remember how many shots you fired, the color of the guy's shirt. There'll be all kinds of details that you get wrong, not because there's anything wrong with you, it's normal, but the way our brain captures and stores and recalls information under stress is completely different than the normal experience, right? We're hearing a lot about this with the breathing and so forth that we're doing in the mornings. And like I said, there's always a greater than zero risk of getting convicted. And I don't care how innocent you are. I work cases where the client's offered a plea. They don't think they did anything wrong. They don't want to take a felony plea. But the alternative is 20 years in prison if they get convicted. And I have to tell them, listen, if we go to trial and I put you in front of a jury, I don't care if you're the most innocent person I've ever worked for. There's a 10% chance you get convicted if I put you in front of a jury. That's just the noise in the system, folks. Juries are dangerous and unpredictable creatures. And then the client has to decide. They want to roll the dice, 10% chance of getting 20 years, or they want to take a plea with no time. That's the decision they have to make. And they're put in that position once they've decided to go hands-on in that fight, because they've lost control after that point. So again, jury's dangerous and unpredictable. You've all heard the phrase jury selection. Folks, I don't get to pick your jury. I don't get to select your jury. If I got to select a jury, I'd never lose. Right? I have a modest ability to deselect individual jurors, but I'm largely stuck with the jury pool in your community. What's that going to look like? How many of you have tried to get out of jury duty? You know, nobody wants to admit it, but most people have tried to get out of jury duty. So who do you think is left? And of course, the jury knows less than anybody. Because in theory, they come in as a blank slate. They're not supposed to have any preconceptions about what happened. Anybody serve on a jury before? Okay, so you know, right? You're supposed to be able to say, hey, I can be impartial. I come here with no preconceptions. You're literally a blank sheet of paper. So you know less even than the defender or the cops or the prosecutor or the judge. You know less than anybody. Again, most common thing I hear is, I can't believe I'm prosecuted for self-defense. And by the way, none of this should be seen as a knock on prosecutors. This is what we hire prosecutors to do, right? To prosecute bad actors in our community, especially violent bad actors, take them off the street so we and our family don't have to deal with those people. But if a prosecutor's decided that you're a reasonable target to bring to trial, guess how he views you? He doesn't think he's prosecuting a law-abiding member of the community. He thinks he's prosecuting a felon who should be convicted and sentenced to prison, just like every other dirtbag that he prosecutes. Again, that's why the system doesn't care. And if they do take you to trial, their conviction rates at trial are in excess of 90%, often 95%. At the federal level, it's 98% conviction at trial. Well, is that because they're super lawyers? Well, some of them are great lawyers. But it's because they get to choose the cases they bring to trial, right? They have the discretion. The bad news is if they take you to trial, it's probably because they think they have a lot of evidence against you, because they are professionally scored on this percentage. They want to maintain this percentage. And they will jealously defend that percentage. But that's actually good for us, because that means that if you do things right, you can make yourself hard to convict. And if you look like a hard to convict case, they don't want to take you to trial because they might lose, and they don't want to lose because that'll lower their winning percentage. So that's our mission when it comes to the legal fight, is to make ourselves appear as hard to convict as possible. And that means having those 5 elements in your little narrative of self-defense. The good news is when you have those elements, you don't have to prove them. You don't have to prove innocence, imminence, proportionality, avoidance, and reasonableness. The state has to disprove one of them, only one of them, but they have to disprove one of them beyond a reasonable doubt. That's a pretty high threshold. So unless you really screw things up, you should be well within the lawful range on each of those. It just requires you have to know what the elements are to know which ones, not to violate any of them. Stay inside those 5 elements in any reasonable way, and the prospect of disproving them beyond a reasonable doubt, you can get very, very close to 0. Never 0, but super, super close to 0, and that's what makes you hard to convict. Now, just like in a physical fight, of course, the best way to win a fight is if you don't have to fight in the first place. Right? And that's the same for the legal fight. Again, once you're hands-on in the physical fight, you've lost control over the legal fight. Your future's not up to you anymore. So if you can avoid the fight, consistent with safety, then I would urge you to do that. Now, I know different people will draw lines in different places. There's a certain sheepdog community in the self-defense. I'm not telling people what to do. I never tell people what to do. If you want to get yourself involved in a fight, that's up to you. I just want you to do it in a well-informed way so you understand the risks. The moment you go hands-on, there's that 10% chance of getting convicted of some underlying crime, regardless of how innocent you were. So, a few miscellaneous things. Sometimes people ask me, can this be used against me in court? Can that be used against me in court? Folks, can X be used against me in court? I don't care what X is. The answer is always yes. It's always yes. If by used against me in court, we mean, can a prosecutor talk about this in front of a jury to make me look bad? The answer is always yes. The prosecutor can talk about anything. What really matters is how damaging is it likely to be and how easy it is to mitigate that damage. So you have an NRA sticker on your car. Can that be used against you in court? The answer is yes, of course. Is it likely to be damaging? No, not particularly. Lots of law-abiding people are members of the NRA. But if you have on your car window, or you have a sign outside your house, trespassers will be shot, survivors will be shot again. Can that be used against you in court? Yes. And the trouble with that is it lawful to do that? No. If you have a terrorist hunting permit sticker on your truck and you happen to get into a confrontation with someone who's Muslim and you kill him, can that sticker be used against you in court? Yeah. And does that go to a certain state of mind? A malicious state of mind? Absolutely. So I do worry about things that go to state of mind that can suggest that those Punisher backplates they sell for Glock pistols, right, that are so popular. Who's the Punisher? He's a cartoon character who's what? He's a vigilante. He uses force outside the legal boundaries. You think that would be used against you in court as going to your state of mind? You think you're the Punisher? You think you have the authority to use force outside the law? If I were a prosecutor, I would talk about that all day in front of the jury. And does it help you win the fight? Does your Glock run better when you put that backplate on it? No. So please don't do things like that that go to your state of mind. A couple of examples there. We don't call 911. Please, folks, don't put that stuff up. I talked about proportionality before. If you're threatened only with non-deadly force, you can only use non-deadly force in self-defense. That's that element of proportionality. You can't use deadly force in self-defense unless you're threatened with a deadly force threat, meaning a threat likely, not just theoretically possible, but likely to cause death or serious bodily injury. Is a typical thrown punch likely to cause death or serious bodily injury? We know people are killed by one punch, right? We've all seen the videos. But is that typical of a thrown punch? It's not. And the courts will treat a thrown punch invariably as a non-deadly force attack, against which, guess what? Your gun is not a lawful response. Anybody want to get punched? No. You want to be able to defend yourself against that punch. But the gun is not going to be a lawful response. And if you go disproportional, if you go to your gun against a non-deadly force threat, you've gone disproportional, you've lost the element of proportionality, you've lost self-defense. And those are the large majority of cases I work on, where people got a concealed carry permit, they got a gun, they're walking around, they get scared. Somebody scares them in a Walmart parking lot or whatever, they pull that gun out, and then they can't explain to the authorities afterwards, where was the deadly force threat that you were defending yourself against? And they get charged with aggravated assault with a deadly weapon, and they're looking at 20 years in prison. So make sure you have some non-deadly means to defend yourself. And that could be your bare hands, that could be BJJ, that could be, where's Alex? Pepper spray, there's Mr. Alex, the palm guy. I'm a big fan of OC spray, but I don't really care what your means of non-deadly self-defense is. But have something. I mean, according to the FBI Department of Justice crime statistics, you're 5 times more likely to be threatened with a non-deadly attack, a simple assault, a simple battery, than you are by a deadly force attack. But if all you have is the gun, what happens when you get scared? You go to the gun. It's the only defensive tool you have. You go to that only defensive tool and you get charged with a felony afterwards. Even though you were really defending yourself, just not against a deadly force threat against which the gun was lawful. So don't put yourself in that position. Make sure you have a non-deadly means of self-defense. Again, most of the cases I work on are these aggravated assault with a deadly weapon charges. People end up looking at 10 to 20 years. By the way, merely preparing for having the ability to use pepper spray looks good. You end up going to your gun, your lawyer can argue to the jury, listen, he would have used the pepper spray if this aggressor had given him any opportunity to do that. But he had to go to the gun instead because of the degree of aggression he was threatened with. Often people will say things to me like, well, listen, I don't want to be a lawyer. I don't want to learn the law. I don't want to learn this stuff. If I get in trouble, I'll hire a lawyer. That's what lawyers do, right? They fix your legal problems. And I appreciate that vote of confidence, folks, but listen, your lawyer, me, any lawyer, is stuck with the facts that you give them. We don't have a time machine. We don't get to go back and change what you did. If you give us good facts, we can make you damn hard to convict. I mean, I have almost a perfect record for my clients of getting charges dismissed, or at least the client getting put into a diversion program, so if they keep their nose clean for a few months, the charges go away. But part of the reason I have an almost perfect record is because when a case comes to me with bad facts, I can't help that person. And I don't take their retainer. I don't take their money because I can't help them. If you give your lawyer bad facts, you got a serious problem because he may take your money. I mean, most of them will take your money, but he doesn't really think he'll be able to defend you. He's just working his day job. So you want to be in a position where you can give your good lawyer good facts. Again, I don't care how innocent you are, you do everything right, you could still get convicted. So I would encourage all of you to think to yourself, think about what circumstances getting convicted would still be worth it. All right, you get charged with aggravated assault with a deadly weapon. You get sentenced to 20 years in prison. On that 20th year, under what circumstances would you be able to tell yourself, all right, 20 years in prison, man, that sucked, but it was still worth it. If I had to do it again, I would do it again. You shot and killed someone, you're sentenced to life in prison. Under what circumstances would that be worth it? Because there's always a chance of getting convicted, right? 10% chance no matter how innocent you are. Now, there are circumstances in which it would be worth it, even life in prison, right? I'll just talk about me personally. I don't want to tell you where that line is, but I'd rather be alive in prison than dead outside of prison. So if the alternative was dying, then it was worth it to press that trigger, even though I got sentenced to life, and I would press that trigger again under the same circumstances, because I don't want to be dead, right? Or to have that happen not just to yourself, but maybe your wife. Not the first wife, the current wife, the good wife.
Now we gotta edit.
Now, do you? You gotta edit that? I tell that joke every class. So yourself, your wife, your kids, right? If they were imminently threatened with death or maiming or kidnapping or rape, which are all under the law, deadly force, acts of aggression against which deadly defensive force would be justified, yeah, I'd rather end up convicted and be in prison than have any of these things happen. But once I get past this list, I'm not telling you what to think, but me personally, once I get past this list, it's really hard for me to think of things that I'd be willing to spend the rest of my life in prison for, or any time in prison for. Like coming to the defense of a stranger, because you don't really know what's happening in a defense of stranger situation, right? You turn a corner, you see a fight, maybe it looks bad. I mean, we all see these videos where we see someone being attacked on a subway and everyone's just standing around looking, and they're like, well, why isn't anybody helping that person? Well, one of the reasons they may not be helping them is because in their community, when someone helps, they often get criminally charged and they often end up getting convicted over a stranger. And I'll tell you, man, when I see those situations, I'm like, when I became an adult, I went out and I got a gun and I got a concealed carry permit and I learned how to shoot it and I learned what the rules were. I prepared myself for a fundamental adult responsibility. That person could have done that. Why aren't they defending themselves right now? And their failure to do that, does that make them my responsibility? I got 4 kids, man. I got to raise 4 kids. I can't go to prison over somebody else. Now, there are different defense of stranger situations, right? Defense of other situations. Some others are people you know. Family members, neighbors, you know something about their character, you know whether it's likely they were a bad actor. Then there's real strangers that you really don't know anything about them. And by the way, their interest may not be your interest. You've been a cop for just a couple of years, is that what you said? Have you done a domestic call yet? Domestic violence? Yeah, of course, right? The first week probably, right? You ever run into a situation, any other cops here, where you went to the domestic call, the woman is being violently abused, you go to cuff up the husband and the woman turns on you? Because she doesn't want her husband going? How do you think she's going to testify if you came to her defense? Not even a cop, and defended her. You think she's going to say, oh yeah, he defended me against my husband? Or do you think she's going to say, no, my husband wasn't doing anything. I wasn't worried about that. I wasn't scared until this showed up with a gun. How's that look for you? If the person you supposedly rescued is willing to testify against you, you have any control over that? You just put your life in their hands, that woman's hands, a stranger, whose interests are contrary to your interests. I'm not telling you not to do it. I just want you to make an informed decision. And then I think the third defense of other situation is really like an active shooter situation, where they are strangers, but there's no ambiguity about what's happening, right? Someone's walking through a mall, potting people with a rifle. There's no ambiguity about that. I'd like to think, or a school shooting. And I've never been a cop, I've never been in the military, I don't consider myself particularly brave. I'd like to think if I could take the shot and stop that threat, I would do that. I guess you don't know until you're in that situation. But I'll tell you one thing, if I'm in that mall with my family, you better have brought your own gun, because my priority is getting my family to safety, not being a hero for you and leaving them at risk. What about defense of property? Any property you're willing to spend years in prison over? You got a super nice car, you're willing to go to prison over your car, someone steals your car? Happens all the time, though. People get into deadly force fights over their shit. And I get it. You work hard for your shit. Your life, energy, time was spent earning the money to buy that shit. I don't want my shit taken either. And I'm not telling you not to defend your shit. In most states, 49 states, if you use deadly force purely to defend your shit, though, in the absence of a threat to persons, that's automatically unlawful. You cannot use deadly force to defend personal property, like an unoccupied car, like a laptop, like a cell phone. Texas is the exception. Even there, I wouldn't recommend it. Someone insults you, or insults your wife, or insults your kids. That sucks, right? Nobody likes that. We're men, aren't we? Right? You willing to go to prison over an insult? I mean, I meet a lot of people who, I remember what it was like when I first got my concealed carry permit. And I came from a place in New York where you couldn't get a gun. You couldn't get a concealed carry permit for sure. And then I found myself living in a place where oh my God, I can get a concealed carry permit. I can carry a gun on my person just like a police officer. And you put that gun on, you go out, it's under, and it feels empowering. Now that I have a gun, I don't have to take shit from anybody. Man, now that you have a gun, you have to take shit from everybody, except the person trying to kill you or maim you or rape you or kidnap you or do that to anybody you have a duty to protect. But just insults or offenses, you can't afford the legal liability that comes with going to the gun. Again, 10% chance of going to prison for the rest of your life if you end up having to kill that guy and your self-defense claim fails. So I urge you to think about all this stuff today. When the gunfight starts, the kickoff to the gunfight is not the time to be thinking about where your personal boundaries are for when you're prepared to use force. Again, I'm not telling you where to draw those boundaries, but you should draw them in a well-informed way, and you should do it today, now. And of course, we can't foresee every possible detail of every possible violent encounter, but they tend to fall into general buckets, right? An armed robbery, a home invasion. So you should bucketize things you read in the news, events that you hear about, and say, all right, what would I do in that situation? Use that as a training opportunity, like a pilot. Any pilots here? Someone's a pilot, right? Right? You study airplane crashes, right, of other pilots to learn from them, right? Learn from these violent events that are reported in the media and think to yourself, Where are those 5 elements that Andrew Branca talked about if this person's going to claim self-defense? Which ones are strong? Which ones are weak? What could this person have done differently to make themselves harder to convict? To give their lawyer good facts so he can make them hard to convict? To make themselves look like such an unattractive target for prosecution that they're never going to be prosecuted because they look like too hard a case to win, and the prosecution doesn't like to bring tough cases to trial because they want to maintain that 95% win rate. So I would urge you to think about all this stuff now. And when it comes to the physical fight, we do what we're doing here this weekend, right? To prepare for this physical fight. We get tools, we get training, and we practice. We get guns or knives or whatever your tools are. You come to a place like this to get training in those tools, and hopefully when you go home, you don't just stop, but you are continually training, maintaining your expertise, your competence with these tools and training. Well, you have to do the same thing with your legal defense folks. You're all going to get a copy of my book. I'm glad to give it to you. But if all you do is put it on a bookshelf, or even if all you do is read it once, that information is not going to be actionable for you in a moment of crisis. It just won't be there. Just like if this was the only thing you ever did with a handgun in your life, and a year from now, you think you'll be proficient defending yourself or your family with a handgun? That's not the way it works. So what I would urge you to do when you get the book is go ahead and read it. It's an easy read. Most people read it in an afternoon. It's not complicated. But then leave it in a place, a convenient place, your nightstand, some place where it's accessible, where occasionally you can pick it up and just open it at random and read 2 or 3 pages. Maybe the bathroom would be a good place for that. I don't know. Read 2 or 3 pages just to refresh your recollection so you keep this information actionable for you in the moment of crisis, because otherwise it just doesn't matter. The last thing I'll mention, and then I'm happy to take questions either now or if we don't have time now, anytime over the course of the rest of the S12, is we do an occasional webinar on this stuff. Make yourself hard to convict. It's our hard to convict webinar. It doesn't cost anything. So if you don't remember anything else, just remember lawselfdefense.com/hard-to-convict, and you can sign up for that webinar. It doesn't cost a penny to do that. And that's the last slide right there. Do we have time for any questions, or?
Who's got a question?
Alex?
In Florida right now, with the hurricane and the wreckage and all that stuff, there was a message sent that looters, if you come to the property, you will be shot. So I was curious, and how would that pertain to presenting the 5 pillars or anything like that you would say?
Yeah. So I do YouTube videos almost every day of the week. So if you look up Law of Self-Defense on YouTube, they're all free. You can watch all of those. And I actually covered that. So the governor, future president, Ron DeSantis, came on TV. Am I jumping the gun? I don't know. It feels good to say, though. So Governor DeSantis got on TV and he basically said, hey, listen, I happen to be seeing on, like spray painted on garage doors, you loot, we shoot. And, this is a Second Amendment friendly state, and you don't know what's behind any of those houses. And if I wouldn't want to be the person who's trying to loot and encounters a homeowner who's, owns guns. And what he never said was you loot, we shoot. He never said that was lawful to do. It's not lawful to do that. You can't shoot someone just because they're looting in the absence of some threat to persons, especially an unoccupied, abandoned home because a hurricane has come through. So there's no threat to person, they're going into an empty structure. You can't use deadly force to defend personal property, even in Florida, even in this hurricane type situation. What he was saying was, listen, if you do that, don't be surprised if someone shoots your ass and kills you over it, and maybe I won't be that concerned about prosecuting that person. But it's not actually lawful to do that. Now, if you're still in the house, well, then it's just a burglary offense of an occupied dwelling, and then all kinds of special privileges come in to use deadly force there. But if you're in your home and you're seeing your neighbor's home get looted and there's nobody in that house, there's no threat to persons, you can't just shoot those people as they're carrying the TV out of the house. As much as we might like to, unless you're in Texas. Texas is the one state that allows for the use of deadly force in defense of mere personal property. But you better hope that legal defense works, because if it doesn't, off to prison you go.
Thoughts on keeping accurate training records?
It depends on the quality of your training. And it depends on whether you adhere to that quality training. So if the training is good, like you guys are getting here this weekend, and you do that, that's great. because it goes to the reasonableness of your conduct. Here's how you were trained to a reasonable standard, and you adhere to that reasonable standard. If you go get training some lunatic who says bullshit on the internet, and that's your training, and you think you want to introduce that lunatic to your jury, that's not a good idea. And if you follow that advice, it's not a good idea. Or if you get good training and then you do the opposite of your training, that's not a good idea, because then you were trained on what was reasonable and you didn't do it. So it's largely a function of, you know, was the training good? So get good. Listen, if you want to get training from a lunatic, go. Oh, sorry. I'm from New York. If there are some, how can I put it, large personality self-defense trainers out there, right? I don't want to name any names, but we all know who they are, probably. I'm not saying don't get trained by them. Go ahead, get trained by them, but that's not the training records you would want to introduce to a jury, right? You just keep that on the down low. And by the way, when you do get trained, so you learn all kinds of specialized stuff in a class like this, right? I don't know if we're going to cover anything like the Tueller drill. Probably most of you have learned the Tueller drill, but you learn all kinds of. So juries are presumed to possess common knowledge, things that we all know. Fire is hot, ice is cold, knives are sharp, right? So the jury just knows that stuff. What they don't know is they don't know how guns work, how ballistics work, how many times you might have to shoot someone. They don't know any of that shit. They don't know the Tueller drill. Now, if you know that stuff, and that knowledge informed your decision-making in self-defense, that's what makes your use of force reasonable. You applied your powers of reason to the threat in front of you based on your specialized training and expertise. You want that specialized knowledge introduced to the jury. You'd want a guy like Mickey to come in and say, yeah, this is how we trained him. This is why we train him, and this is why it's reasonable. But to get that kind of evidence in front of the jury, you have to be able to prove that you possessed that knowledge at the time you acted in self-defense. Because if you only learned it later, it could not have informed your decision-making in self-defense, right? And unfortunately, a lot of people go get training, and then they can't prove that they got the training because they didn't document it in any way. Now, you don't need a lot of documentation. You need basically more than zero, a certificate, a syllabus, your own notes. Any of that would be more than sufficient. But you need more than nothing. Because if you have nothing and you say, oh no, the reason I did this was because Mickey trained me, and you don't have any record of it, or any record of the training, any notes to yourself, the prosecution's going to say, hey, for all we know, he read that in a gun magazine after he shot that person. That's not admissible to the jury. And the judge is going to agree. So when you do take training courses, good quality training courses, make sure you make notes. Send yourself emails. Keep a syllabus if they give it to you. So that you have that more than zero amount of evidence of that training to get in front of the jury. Unless you get training from some lunatic and burn that shit. You don't want that in evidence.
Like you stated, jurors are not the class of people you want to judge you.
They're not your peers, not how we think of peers.
Excuse me, a bench trial instead of a jury trial.
All right, so the cliche in... Get it back? The cliche in legal circles is that if you're guilty, by the way, most criminal defendants are what? Criminals. So most of them are guilty. That's what the system is designed for. If you're guilty, you want a jury trial because you're hoping your defense attorney can sway the emotions of at least one juror to vote not guilty, and then at least you have a hung jury. If they want to convict you, they have to try you again. So you want to be able to leverage the emotions of the jury. If you're innocent, the prosecution can do that against you. The prosecution can argue to the emotions of the jury. The jury becomes a risk. So if you're innocent, normally you'd want a bench trial. A bench trial is one in which there's no jury. The judge plays the role of judge, of the finder of law, and he also plays the role of jury, the finder of fact in the case. And he's obviously a professional, a legal professional, right? He's a technician, a legal technician. He's not going to be swayed by emotional arguments. So if you're innocent, you want to strip the emotional arguments out of it completely. You can make your case on the evidence and the law to a legal technician. That's where I'd want to be. The trouble is, in most states, you don't get to demand a bench trial. You have a right to a jury under the U.S. Constitution, and in most states, the prosecution also has a right to a jury. So you have to get them to agree to a bench trial. And if they want to be able to try to sway the jury with emotion, they're not going to agree to a bench trial. There's a few states Maryland is one. Anybody remember the Freddie Gray prosecutions, the 6 officers in Baltimore? They arrested this street corner drug dealer, put him in a van. When the van opened up, he had a broken neck, probably because he stood up in the van, you know. And there was literally zero evidence in that any of those officers had used any unlawful force against him. There was zero evidence. And they prosecuted those cops for crimes as serious as murder. But in Maryland, they were able to demand a bench trial and get it. The prosecution had nothing to say about it. So all these arguments were made to a judge, and every time it was made to a judge, one cop, next trial, second cop, next trial, third cop, the judge said, acquitted, 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 because there's no evidence here. The prosecution was going crazy. They wanted a jury so bad they could taste it, because they knew they didn't really have the evidence, but they also knew the cops were, well, they weren't, it was actually a mixed race group of cops, but the victim was black. It was going to be a racially energized set of trials, and they wanted to be able to appeal to the emotions of the jury, and they weren't able to do it. But I don't know what state, obviously, all you guys live in, but normally you don't get to demand a bench trial. It's not up to you.
I was sent a text message while you were speaking, and it says, "Holy shit, he's a good speaker." that was sent my way.
Thank you very much. Who was it? Was it Z? Who was it?
Nope, it wasn't Z. So you guys should get a picture with him. He's literally the Ron Jeremy of the...
It's true. Amen. Thank you.
Visit our website, CarryTrainer.com, for information about classes held throughout the U.S., CarryTrainer apparel, and upcoming projects. You can also email us at training@CarryTrainer.com for information about setting up your own private course or speaking engagement. Training@CarryTrainer.com or CarryTrainer.com. Oh, hey there. Mickey with CarryTrainer, Drew behind the camera today. It's a beautiful Radian weapon. You know, I think to myself, I'm really glad I always have this thing with me. I never am without it. That and my trusty Glock 19. I've always got them both, so any problem that comes my way, I can solve them. Of course, I'm joking. And the other thing is, even if I've always had these guns don't solve every problem. They solve a very narrow set of problems, and those problems are something that requires deadly force. If you bring a firearm into a fight, you are telling the world you were in fear of death or great bodily harm, or that you're an idiot if you didn't need the gun. Open hand skills are fantastic. Verbal judo, the ability to communicate with somebody and maybe back them up. Maybe running away is important, but what about less lethal options? Things like pepper spray. And that's what I want to talk to you about today. We've got some stuff here from our friends at POM, P-O-M. And what I like about POM, made in the USA, folks have said to me, hey, I don't know who POM is. Who's POM? Well, if you've seen any pepper sprays in the last 30, 40 years here in the USA, POM is involved in them in some way, shape, or form. They own the patents on a bunch of the parts that make all the big name pepper sprays work. So if you look at this and you're like, oh, that's just some new company, I'll stick with the big guys. Make no mistake, these are the big guys. They've been making the parts utilized in all that stuff for a long, long time. When they designed this, what they were thinking about, POM, was being able to keep it in your palm. Now you think about a lot of us that have something like this, especially the ladies, I'm not knocking on you, but you get some of this and where is it? Yep, it's in the bottom of your purse or in your glove box or at home. In order for this to be of use, it's got to be accessible, especially when we think about when we need this stuff. Usually it's some type of ambush situation. Somebody comes into your space and you need it to be able to deploy it quickly to repel them. As you're moving about spaces, places, this can be in your dominant hand, keys maybe, or whatever else in your other hand, or nothing at all, unless you got a briefcase or bag or something like that. But practicing carrying this is something that you should be doing as you're moving about. Just as important, POM makes a inert solution. So it's really just water. It's It's not going to hurt you. It's not going to burn you like this stuff would. Doesn't mean you shouldn't practice with a real one, but make no mistake, this stuff sucks to get in your mucous membranes. So if you order some of this, get 3 or 4 of the inerts so that you can practice. If you give one of these to your daughter, your wife, if you have one, practice with this so you understand what's coming out of the stream or what that stream looks like when you deploy it. Because what often happens is if we never, ever, ever see it, you don't want the first time that you use this and it's to try to get somebody away from you. You don't want that to be the first time you've ever seen what it does or how far it shoots or what that stream looks like. So grab some of each. Palm pepper spray, made in the USA, made for everyday carry, easy to hold, easy to use, affordable. And hey, we've got a discount code. It's CarryTrainer. Buy yourself some of the actual spray and some of the inert palm.